Hi everyone, Harry here to talk about the latest lawsuit and sort of cultural war over gender identity, trans surgery, and the like. We actually already have a case that the Supreme Court has taken involving a state law that forbids treatment for trans patients. And here we have the other side. So a suit brought by Missouri along with half dozen states against the HHS. What did the HHS do? They took the ACA, Obamacare, and there's a provision, it's law that Congress passed in Obamacare, Section 1557, which bars discrimination on the basis of sex. Does that bar discrimination on the basis of what's now called gender identity as the sort of encapsulation of patients who want to have trans surgery or are thinking about it or have gender dysphoria and are, need treatment on that basis? Now, the HHS promulgated a rule, and the rule actually fairly well tracks a Supreme Court opinion from a few terms ago by Justice Gorsuch, who in a plain meaning reading said sex discrimination includes discrimination on the basis of sexual orientation. And in a similar chain of reasoning, HHS says the mandate by Congress not to discriminate on the basis of sex includes a mandate not to discriminate on the basis of gender identity. That's now sort of part and parcel of sexual discrimination, and goes on in letter and verse to cite the things you may not do and that you have to do. Essentially, you give sort of you treat as a full-fledged condition the psychological desire to change gender, but also the actual reassignment surgery and the like. This puts red states absolutely fit to be tied, and the law in the Supreme Court is one reaction. These states now are suing the HHS, and they're saying, first and foremost, they're saying, you got it wrong. I know that Justice Gorsuch might have said in this Bostock case that sex includes sexual orientation, but we get off the train at gender identity, and you should as well. So first, they offer a plain meaning. 1972, that's when the relevant anti-discrimination provision was passed. Dictionaries, to say gender identity discrimination is not part and parcel encompassed by sex discrimination. So that's just for starters. As a matter of plain meaning, it doesn't, cut the mustard as a matter of textual analysis. But then point two is another really interesting one involving the Supreme Court. You heard at the end of the term that, yes, the immunity decision was big, but as I said then and others, what's really going to have more impact day to day is the overruling of the Chevron case, which gives certain deference to administrative agencies for interpreting ambiguous provisions in a law. And they come right out and say, Chevron's been overruled, no deference to the HHS interpretation. So the sort of second part of the plank is, we're not kind of leaning over one way or another. You're just playing it down the middle court, and you should hold gender identity is not encompassed within sex discrimination. So basically, it's a textual analysis, but then it goes through a lot. I mean, there's really part of a, it's not just cultural wars, but, medical disagreements. So they go chapter and verse through why, especially young patients who have gender identity problems and especially reassignment surgery can wind up with, really lifelong difficulties in a number of ways, especially sexual and reproductive, and trying to make the case not simply that this isn't covered by the plain meaning, but that it's medically unnecessary and even harmful. Now, the federal reg, as interpreted by HHS, of course, doesn't require gender reassignment surgery and doctors exercising best interests, presumably meaning with some patients refusing the surgery or going for counseling or whatever. But there's a sort of worldview that I think is out there and also comes through in this complaint of basically, crazy government doctors just hailing in patients and like gender reassignment mania out there. But, be that as it may, the real battleground is on this, basic notion of plain meaning and a sort of like stopping point in the overall anti-discrimination social consensus that would basically say, I'm against sex discrimination the same as anyone else. Women should have the same rights, et cetera, et cetera. But gender identity, this is a different thing psychologically, medically, and I think it also just goes to the whole, there's talk about males confined to female spaces and bathrooms and that whole kind of thing that is the sort of, whipping horse of the, especially the, political objection to treatment of trans patients as a kind of crazy adjunct of the liberal state. So they are looking, these 6 states are suing for a preliminary injunction to say, don't have this rule go into effect, and then you have a full trial to say, to overrule it. It's going to be really connected to that Supreme Court case I said before, and I think it's inevitable that this issue is going to bubble up and make its way to the courts of appeals and very likely the Supreme Court, and that then in particular, the overruling of Chevron, the Loper-Bright case, and the principle of not deferring to administrative agencies. This is going to be a very kind of prime candidate for now saying, we don't have to listen to HHS's basically crazy social liberal views, pro trans patients and the like. So it's a case that very much conjoins medical issues, psychological issues to social issues and issues of the culture wars. And the 6 states in there saying what the HHS got it wrong when they housed or put gender identity and all that entails, which is kind of laid out in a somewhat hyperbolic fashion. But all that entails within the general principle of anti-discrimination. And so it's just about interpretation. Now notice this statute is forced on states, not forced on, it's part of the spending clause. So all this money is given. If you want the money, you have to follow certain federal provisions. And does that affect the interpretive question? And just in general, is there a difference between spending power and sort of flat out anti-discrimination demands? That's a sort of subsidiary, pointy-headed legal issue embedded in it. The real fight here is legally and culturally, does the general social consensus against discrimination on the basis of sex encompass a commitment to non-discrimination on the basis of gender identity? And that's what this big lawsuit, which is just starting, poses. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.